Straight ahead on Law and Crime Daily. A key decision to protect the identity of the jury, which will judge R&B artist R. Kelly.
Plus, a win for a Black Lives Matter organizer at the Supreme Court. And a developer has big plans for Jeffrey Epstein's Florida mansion.
Also,
he reached rock bottom.
Closing arguments in a triple murder. A baseball bat is the weapon. A former pro player is the defendant.
There's absolutely no motive.
Law and Crime Daily covers court cases from coast to coast.
And welcome everybody to Law and Crime Daily. I'm Aaron Keller along with Brian Buckmeyer and Terry Austin. A federal judge has ordered an anonymous jury in the trial of R. Kelly, the R&B artist, seen here at an Illinois state court hearing, faces federal sex trafficking and racketeering counts in New York. That's where a federal judge has ordered the anonymous jury, which she says is appropriate. The judge lists the serious nature of the charges, the defendant's history of obstructing the process, the potential for juror intimidation, and intense media interest as reasons why an anonymous jury is necessary. Prosecutors have alleged that Kelly and his associates persuaded several people to lie during a 2008 state court case in Illinois, and that Kelly even told an associate to contact a juror in that case. Brian and Terry are here now along with criminal defense attorney Linda Kenney Baden. Terry, let's start with you. I usually see anonymous juries in cases that involve drug cartels, mafia cases, gang violence cases. Does R. Kelly belong in a similar category?
You know, I think every case has to be decided separately, but if anybody should be in this category, I do think it's R. Kelly. He's been, convicted or at least he has been accused multiple times before. And if in fact he did say that someone, during his earlier trial should be saying that he is a good guy, and if in fact he did persuade multiple people to give false testimony, then I think this is the perfect case. And I think Judge Donnelly made the right decision here.
Linda Kenney Baden, the defense says it cannot adequately conduct voir dire questioning of jurors without knowing who they are. That at least seems like a legitimate complaint from the perspective of due process of law. Do you agree?
Well, yeah, I've actually been through this process, or non-process, I'd like to call it, in the Phil Spector case, where the judge decided there that the jurors had to be anonymous. Now, when you're representing a client and you're trying to pick the jury that is going to have the most honest opinion of your client, it'd be nice to know a little thing about the jury, like where do they work? You don't even necessarily have to know their names. But, there's some things that defense attorneys can do to get a fair trial for their client. And one of the things is like a seance to see who these people are.
So, Brian, do you often see requests like this? Do prosecutors just reserve them for high-profile people, or what's the parameters here?
So I've never personally seen this type of request, unlike Linda Kenney Baden. I've done attempted murder cases where there have been allegations of witness tampering, and that never happened. So I've never seen this personally. I've seen it just like our viewers. It's only on high-profile cases.
So, Linda, how do you try to actually seat a jury then with these restrictions?
Well, you try to let the judge give you jury questionnaires that are so in-depth that you know exactly what their profession is, their education is, et cetera, so that you could develop a profile for your jury consultant to go over with you. And then you rate them based on the questionnaires and wait until they get into court. That's the best you can do, but you can't do anything to see if they're in bankruptcy, if they've ever had a law case, if they've ever had a legal case, if they've ever been sued. You can't do any of that background work.
And without all that background work, you may wind up potentially, Linda, with a juror who isn't even qualified to serve.
Or a stealth juror who has made comments, especially nowadays in social media, if you don't know who their media profile is.
Yeah, a lot of questions for R. Kelly's defense attorneys, but that's the decision from the judge, anonymous jury to prevent any tampering. Attorneys for Kyle Rittenhouse are working to raise millions of dollars to post his bail. Rittenhouse is charged in Wisconsin with murdering two men during protests surrounding the police shooting of Jacob Blake in August. The 17-year-old is charged as an adult, and he's being held on a $2 million bond. One of his lawyers, Lynn Wood, tweeted that they've already raised more than $1 million and that they need about $600,000 more. Wood said that there isn't an iota of evidence against Rittenhouse and that the teen was attacked while trying to help people. A win at the U.S. Supreme Court for the organizer of a Black Lives Matter protest. Law and Crime's Brian Buckmeyer explains. Brian, how'd the case come about?
Aaron, the whole thing started in Louisiana when someone threw a rock or a piece of concrete during a Black Lives Matter protest for Alton Sterling. The object hit the officer, who suffered a brain injury and lost several teeth. The police officer decided to sue, but part of the issue is that no one knows exactly who threw the object. So the officer named DeRay Mackinson as a defendant. Mackinson helped organize a protest, and the lawsuit claimed that he should be held liable for the officer's injuries. A lower court of appeals agreed, but the U.S. Supreme Court did not. The Supreme Court sent the case back to the lower case with instructions that the Louisiana State Court first apply state law to the question of Mackinson's liability before they got involved. The Supreme Court questioned but ultimately sidestepped whether holding Mackinson liable would have serious effects on the First Amendment.
Thanks for the update, Brian. A developer is buying sex offender Jeffrey Epstein's mansion in Palm Beach, Florida. Terry Austin is here now with what he plans to do with that property. Terry?
Well, it turns out the developer wants to demolish the $22 million property. Epstein was accused of luring young girls to the property and sexually assaulting them. He died by suicide in jail in New York City last year. Developer Todd Michael Glazer plans to build something new on the lot. He told the Wall Street Journal that Palm Beach is going to be very happy that Epstein's mansion will soon be gone. Glazer declined comment when we reached out to him today.
Thanks, Terry. A state highway patrol report says South Dakota's attorney general was distracted when he hit and killed a man walking on a highway in September. But the report doesn't say what distracted the AG. Jason Rounsberg initially said he thought he hit a deer, but found a human body when he went to check the scene the next day. 55-year-old Joseph Beaver was the man Rounsberg killed. Rounsberg told a 911 dispatcher whatever he hit was in the middle of the road. But a state report says Beaver was walking on the shoulder of the road. And still ahead here on Law and Crime Daily, the trial of a minor league baseball player accused of triple murder. But first, a look at a prosecutor's decision not to retry Michael Skakel for the killing of Martha Moxley in 1975. Skakel's cousin, Robert F. Kennedy Jr., with more on the infamous case, including Skakel's explanation for why his DNA was at the scene. Let's take a closer look now at a decision by a Connecticut prosecutor to refuse to retry a convicted killer a second time after the state Supreme Court threw out his original conviction. Michael Skakel, related by marriage to the Kennedy family, was convicted of beating and stabbing Martha Moxley with a golf club similar to one missing from his family's home. Prosecutors say too many witnesses have died since the 1975 killing and that they won't try Skakel a second time after reinvestigating the case. Robert F. Kennedy Jr. believes he tracked down the real killer and even says he obtained a confession. I recently spoke with Kennedy. Here's how he explained one of Skakel's alibis about why potentially his DNA might be found at the scene.
He went over to Martha Moxley's house and he climbed the tree that he thought was her window. It was not. It turned out it was not her window. It was her brother's window. He threw rocks against the window, and then when he could not get her, he masturbated for a short time in the tree. He didn't masturbate to orgasm, he just said he masturbated. He then thought he felt something weird, and he scurried down the tree and he ran home. And the next morning, Mrs. Moxley came to the house and came into his room and woke him up and said, have you seen Martha? She was looking for Martha because Martha didn't come home. And Michael said, and he says this on the tape, he said, I thought she had seen me. I thought she saw what I did. He wasn't talking about him worrying that she had seen him murdering Martha. He said he was worried that he had been seen masturbating outside of her home. When Jonathan Benedict illegally got a hold of that tape, Michael had told this story to me many times. He told it to many people in AA and many people who he was friends with. And he told it to a writer in Massachusetts who recorded it. And then Jonathan Benedict, who was the prosecutor, cut the tape and put in all kinds of graphics of kind of red blood pouring down it and this kind of thing, and made it look like Michael was confessing that he had been worried that Mrs. Moxley had seen him murder her daughter the night before. And that's what the jury went away thinking.
analysis right now. So Linda Kenney Baden, you consulted on this case. How did the prosecutor get such a horribly doctored video in front of the jury?
Not only that, Aaron, I also did the hearings on the privacy issues out of the Elan school, the private school he was at, before Mickey Sherman actually did the trial. Okay, so the judge allowed it. That's how it happened. Just like in every wrongful conviction across the United States and people with the death penalty, the judge allowed this outrageous tape at the very end that basically took the quote evidence, of which I will tell you there basically was none, and argued inflammatory to the jury that it had to be the Kennedy cousin who did this. It was outrageous. It should have been reversed right then, and it should never be allowed, this kind of conduct by a prosecutor in any court in the United States.
And Terry, you were on the side of this case the other day, basically saying that you think the original conviction was sound, at least in your opinion.
Well, here's what I think. I think at this point in time, it does not make sense to retry the case. I mean, he was convicted in 2002, then he was granted a new trial, and then he was released, and then it was reinstated. I mean, I feel as though he has gone through enough and the family has gone through enough. Do I think he probably committed the crime? I do. Was there enough evidence? Probably not. But at this point in time, I do think it makes no sense to retry the case.
And Brian, the family is basically saying that we agree with the way the prosecutor's handling this. At this point, let's not do a second trial.
Yeah, I mean, that's how the family feels, but at anything, the prosecutor should have done this the right way from day one, and the right way would have been to have the proper admissible evidence come in, and that video, as Linda is stating, should not have come in, that audio tape should not have come in, sorry, and then we would have found out what justice looked like, would have been a not guilty or a guilty, but you had to do it the right way. You can't do it the wrong way here.
So, Linda, again, back to your assessment of this case, there was no DNA actually found, but they got this statement out of Skakel because they said, well, if your DNA does turn up, then how would it have gotten there? And that's when he came up with the story in the tree.
Well, no, he had told this story to a number of people. He had actually had sodium pentothal tests. He had lie detector tests, which he passed early on, okay? Early on, before anything. Let me just tell you, let me just go through this a second. This was done by somebody who was very strong. She was dragged 80 feet. She had, it was a terrible, terrible crime. There were slides of out of her private areas that were lost. There was a hair that was dissolved by the prosecution when they were testing it. There were hairs that were mislabeled. There was a fingerprint on the golf club, which the FBI said, well, they couldn't get a fingerprint out of it, but they didn't exclude anybody that somehow has disappeared. There were jeans that was disappeared. There was evidence that was disappeared. There was nothing that attached Michael Skakel to this crime. There was no forensic evidence, there was no eyewitnesses, and there was an alibi witness. This is why this case was overturned, who said, an elderly gentleman who said he was with him watching TV at his house that Mickey Sherman, the original trial attorney, never, ever even interviewed. And that's why got overturned for ineffective assistance of counsel.
Yeah, exactly. That's what the Connecticut Supreme Court latched onto at least a second time, because remember, the court looked at it once and then agreed that it was a sound conviction. Then new justices went, and then new justices on the court flipped the case. A fascinating case that we will talk about for years to come, I'm sure. And when we come back here on Law and Crime Daily, we take you to California for closing arguments in the murder trial of a former professional baseball player accused of using a bat to commit triple murder. That's right after this. The guilt phase of a trial involving a pro baseball player and a bat as an alleged murder weapon is wrapping up in California. Prosecutors say Brandon Willie Martin slugged his father, his uncle, and a worker to death. The worker just happened to be at the family's home installing a security system. From there, they say Martin stole the security system company's vehicle and led police on a chase that ended with a canine officer biting the defendant.
Dex bit Martin in his left lower shin area. And did the suspect respond in any way? He immediately sprung up to his feet. Okay. And what did he do at that point? He began fleeing backwards through the backyard, and as he was punching Dex multiple times with fists on his head and face. At that point, he was holding the bite and taking the punches. At one point, Brandon bent down and grabbed the dog in a bear hug, which he had the whole dog's body. His face would be facing the dog's tail now, with his back towards his face. and picked him up, and this body slammed his whole weight onto the dog, smashing onto the concrete. The suspect bounced back up on his feet now. He was back up on his feet. Dex was now biting one of his inner thigh areas. He was latched on to the inner thigh, and not knowing what kind of damage the punches were doing to the dog or how much more the dog can handle, I used my rapid containment baton and two-handed strike struck him on his right shoulder collarbone area.
On cross, the canine handler said the defendant was laying on his back, staring up at the sky when police arrived. That testimony is slightly different than that of the arresting officer.
Officer Bajines testified that when he peered around the corner, that Mr. Martin was lying on his side and that he could not see his face. Is it your testimony that he was in fact lying on his back and staring up into the sky?
Yes.
And is it your testimony you were able to see his eyes?
When I said he's staring up into the sky, it appeared. Eyes were open. Don't know what he was looking at, but eyes were open.
That's my next question. You were able to determine that the eyes were open. Is that correct?
Correct.
One time you say, Corona police, show us your hands or the dog will bite you, correct?
Yes.
Do you know, was he able to hear you?
I can't determine if he heard me or not. I would just think he didn't because he didn't move.
Okay. No reaction on the face?
I saw no movement whatsoever.
Didn't even turn to look to see who was talking or what was going on?
I didn't see that.
And when we come back, closing arguments in this case. Will a defense involving drugs and psychotic episodes spare the defendant, or will this case enter its next phase, one which could send the defendant to death row? We're back in just a moment. We're back with the trial of Brandon Willie Martin, who's charged in a triple homicide. The state wrapped up the guilt phase of the case by saying the defendant lost his baseball contract and turned his anger and rage toward his own family.
The defendant, with such power and accuracy, went for the head and hit the head, broke the head open, and having broken the head open, went back to the same spot with such force that paint from that back embedded into the fractures of Michael Martin's cranium. Barry Swanson had defensive injuries. You saw those to his arms as he was beaten over and over and over again. The instrument of death was that black baseball bat, a baseball bat that was once the instrument of his profession. But you know that bat was taken and used to brutally beat 3 men to death. He left that bat in the hallway, and a name engraved on that blood-soaked weapon was Brandon Martin. And that's because, ladies and gentlemen, Brandon Martin is the killer.
The defense says Martin's family was his whole life and that he had no motive to commit the killings.
They weren't just going to toss him out on the street. Mr. Kearse makes much of the fact that Brandon Martin defied authority. When by being told by ETS he can't go home, he defied authority. What is this young man supposed to do? Is he supposed to join the homeless population under the bridge? Is he supposed to grab a shopping cart, put all his belongings in, and sleep in a bush at night? Because what other options did he have other than defy authority by going home? Folks, he had no motive to commit this crime because that was his entire life. The only thing he had was his family. Here he was thinking, I could see the wheels turning and saying, okay, Jensen, if Brandon Martin didn't do this, who did? I don't know. And more importantly, for the purposes of your job, you don't care.
Those are powerful closing arguments, Terry, I thought, just listening to them now.
Yeah, it was powerful, but this is a very tragic case. There's no question that Martin had some mental illness. He had had an attack against his own brother, broke his finger. He attacked his mother. He had scissors where he was going to use them against her. So, I think this is a failure of the system. The fact that he couldn't go home because they were in danger. He should have been in a mental institution. He should have had a diagnosis. He should have had treatment. So something like this would not happen again. It's a very tragic case.
Yeah, but Terry, is that sympathy going to result in a not guilty at this stage?
He's going to get a guilty. There's no question in my mind, just because all of the evidence is totally against him. The only question is, he's not going to get, death penalty. We're in California because, there's a moratorium on that. But the only question is, will he get the mental, care that he needs at this point? That's the question that I have. Is he going to be sent to prison, or is he going to get an institution that's going to help him with his mental illness?
Those are good questions. Brian, I got to ask about the defense closing argument there, because I thought the defense was really picking up traction there, at least making a powerful argument, and then just said, well, you shouldn't care. I thought it would have been better if he said, it's not your job to determine that, and it's not our burden to carry it.
Yeah, stylistically, I think it was a little off. I think it's not powerful. I would say passionate is a better way of saying it, because he did come forward in a manner that made you really believe him. But the question is, believe him in what? He led you to that edge of the precipice and just kind of left you there without kind of walking you past that threshold. And I think that's what was missing there.
Yeah, a burden of proof discussion there, I think, would have helped. Hey, we're out of time here on Law and Crime Daily. Thank you for joining us. We'll see you next time to discuss justice in America.
Hi, I'm Dan Abrams. In the exploding legal and true crime genre, Law and Crime is the only network that has it all.
Good evening and welcome.
This is a complicated case.
Don't really jump to conclusions.
We break down the case of a serial killer.
Another day of drama between both sides.
From multiple live trials daily to original and compelling programming, the Law and Crime Network is everywhere, and we invite you inside the jury box. This is Law and Crime.